Thank you for joining our webinar, ICANN62 Panama City Recap. My name is Brian Costello, Marketing Manager for MarkMonitor, and I'm excited to be joined by my colleagues, Staten Hammock, Vice President, Global Policy and Industry Development, and Brian King, Director of Internet Policy and Industry Affairs. So without further ado, I'd like to welcome Staten to our presentation. Staten?
Good afternoon and good evening, everyone. It's great to be with you. Thanks for joining us today for our Panama City recap, the ICANN meeting that took place last week. It was another good meeting, well attended, but a little bit on the hot side as it's summertime down in Central America and it's near the equator. So we tried to stay cool as best we could. I'd like to start by going through the agenda. We've tried to keep things as succinct and but give you the necessary detail. We're going to talk about quick facts around Panama, the amount of material that was discussed related to GDPR, which again was the dominant topic of the webinar of the meeting. We're going to go through some working group updates. A reminder on how you can get involved in ICANN and the policy development process, and then answer any questions you have. So just to remind everybody, why does MarkMonitor participate in ICANN? Well, we do so for three primary reasons. One, to advocate on behalf of you, our clients, and your intellectual property rights and interests. And we want to work on policies that help enhance consumer trust and safety on the internet. We are also there to actively participate in the policy development process working groups and in the constituency meetings. You'll hear from my colleague Brian at the end of the webinar some updates about some of the working groups that we are actively participating in. And the last reason we attend is to strengthen and deepen the relationships we have with ICANN staff, with strategic partners that are there, supporting organizations, government agencies, and law enforcement, all of which my team is responsible for maintaining those relationships, deepening them, and leveraging them to benefit our clients. So let's go to some quick facts and figures about the meeting. This meeting in Panama City was the shortest of the meeting formats that ICANN sponsors every year. It's called the Policy Forum. And the Policy Forum is an intense 4-day meeting schedule, which is focused primarily on policy work and outreach on a few cross-community high-interest topics. Unlike the annual meeting, there's no big welcome ceremony, there's no public forum to address the ICANN board. In fact, the ICANN board doesn't actually meet during the Policy Forum. Although many were in attendance, probably all of them were in attendance and participating in the high-interest topic sessions, but there was no ICANN board meeting, and there's no sponsor or exhibition area. This year's public forum tracked about 1,100 registrants in attendance in Panama City, and as I mentioned, and no surprise to anybody, the sessions with the highest attendance, participation, interest, and contention probably relate to GDPR, the Temporary Specification, which we'll review for you, and the access model, which ICANN proposed just before the meeting. Other sessions of great interest were the subsequent procedures working group updates. Brian will be explaining those, but there's 5 subsequent procedure work tracks. Those were active during the 4 days. The review of rights protection mechanisms is still ongoing, and sessions related to geographic names at the top level were also well attended. So let's start with WHOIS and GDPR and where we are with this. So as probably all of you know, GDPR became effective on May 25th of 2018, and the impact of that on the domain name industry was that the WHOIS data that we were used to seeing from historically now is redacted in form. So registrant personal data, registrant name, registrant email address, all those informations related to an individual are now being hidden by registrars and registries. And what that's led to is basically a patchwork of different WHOIS outputs. So we've seen that from some ccTLD operators who are not actually bound by ICANN contracts, their public WHOIS data, some of their WHOIS data has been kept absolutely intact. So if you look up a WHOIS record for a certain ccTLD, you may actually see the full WHOIS data. But for gTLDs, you are likely not to see that. You will see the redacted WHOIS data. Some registrars are hiding all of that data. Some of them are hiding registrant email address, and or some are exposing the email address. It's a patchwork of different WHOIS outputs. And with respect to doing WHOIS queries, there's also a fragmentation there. Depending upon where you query your WHOIS at a registrar or a registry, you may see the full WHOIS data, but if you try to access that through port 43 WHOIS or bulk, you're not able to see that data. So registrars, in an abundance of caution, have masked all their data, the registrant data. The temporary specification, which we'll talk to in just a minute, also became enforceable on May 25th on all accredited registrars and registries at ICANN. And that is the genesis for a lot of the actions that have been taken by registrars and registries to comply with the temporary specification. And also, as I mentioned earlier, we've now seen an ICANN proposal for an access model to the non-public WHOIS data. So that has been one of the elements that MarkMonitor and others have been pushing, which is to get access to the full non-public WHOIS data for brand enforcement work. And we're still working with ICANN on that. More to come as we get into the webinar. So let's talk about the temporary specification. Those of you who have missed a GDPR update I gave a few weeks ago, I did go into this, but let me go through it quickly because this has been the subject of a lot of the debate during Panama City, which is, what the WHOIS display looks like now. So again, on May 25th, ICANN adopted or pushed out to the community this temporary specification for WHOIS data. It's called a temporary specification because it is set to expire in 1 year's time, which is obviously driving a lot of policy development now to refine this and to make it permanent going forward. But to recap some of the key elements, the registries and registrars are still required to collect all of the WHOIS data that they were required previously, the full, what we call thick WHOIS data, including registrant name, email address, written address, zip code, and that sort of information. And that full thick WHOIS data is passed to the registry operator and also to the escrow agents as required by ICANN contract. The retention for the data is the life of the registration of the domain name plus 2 years. And there's some waivers for some European registrars who have different data retention policies. The model or the temporary specification allows the registrars to apply the requirements globally, which means they can apply it to not just natural persons in the European Economic Area, but can be applied to all persons, regardless of whether they are natural or legal persons or they are located in the EU. Legal person being, of course, a corporation, an entity, not an individual person. So even though the GDPR was not intended to be so broadly applied in scope, the temporary specification allows registrars and registries to apply it in a global fashion. As I mentioned, in terms of the WHOIS data, with respect to registrant name and email address, that is now redacted. The only thing that is still public is the registrant organization name, if applicable, and the registrant state, province, or country is available. So that is so you can identify for purposes of jurisdiction and taking appropriate action where the registrant is located, but there is no actual street address provided. The registrant email address is redacted as well, although registrars are required to create either an anonymized email address forwarding system or a web form, to allow folks to contact the registrant. Registrant phone, fax, of course, is no longer available. Admin and technical email contacts not available, although email address or anonymized email and web forms are also available as well. There's also a requirement that registrars offer registrants an opportunity and an option to opt in to publish additional data. In other words, if you do want to see your full WHOIS data displayed, you can opt in for that. And many of our clients at MarkMonitor have actually done so. The last bit is the access piece. So in the temporary specification, ICANN required that registries and registrars must provide reasonable access to third parties who have a legitimate interest in seeing the full WHOIS data, except where those interests are overridden by the rights of the data subject. Now, ICANN didn't provide any specifics with respect to how one determines what reasonable access is. So again, we're seeing a little fragmentation in terms of processes to respond to these requests. Some registrars are providing that easily, some are providing it in part, some are providing it with other requirements such as subpoena for additional data. So as we saw with the display, the patchwork of access is also fragmented. There is also a requirement that the ICANN community work on a long-term, more centralized accreditation and access model. And so that's where the shift really happened in this ICANN meeting. It shifted really from talk around display and the temporary specification to what the access should be. So let's talk about the access models out there. So again, right before the Panama meeting, ICANN published a unified access model framework, and I emphasize the term framework because it didn't really have a lot of details in terms of who would be eligible to get accredited or who would be eligible to have access or what the terms and conditions are or what a code of conduct would look like. It was only intended to start framing the community's discussion at ICANN about what access should look like in terms of technical access, accreditation and authorization, eligible entities, and so it was really to kick off that discussion, and that's what many of the sessions related to GDPR, the temporary specification and access were about. What data should be available, to whom, and under what arrangement and what agreement. Obviously, there was no consensus that came, out from the meeting, and this is going to take quite a bit of time in order for specifics to actually, be fleshed out. Now, there have been some work in the community started already, and I'm going to get to that in a bit, that we think could, propel the accreditation and access model along the path to finalization. But as you might imagine, the interest for privacy, the interest of legitimate interest for access, for law enforcement, for intellectual property owners are at odds. And so it's going to take quite a bit of work on everybody's part to get to get some sort of consensus to what the access model is. There's also proposals around, fees to access and what happens if somebody who's granted access uses that data beyond the scope of its interest or a limited purpose. So these are issues that have to be tackled in the months ahead, and I would urge all of you on the webinar to consider providing comments either to us that we could relay to ICANN or directly to express your input, concerns, and urge ICANN to act quickly in putting together this access model. But as I mentioned, there's been other efforts underway for months actually to put together an accredited access model, and MarkMonitor has been participating with a number of folks in the community across different constituency groups to put together an accredited access model. And we've been through about 4 or 6 versions of the model. It aims to be implemented with minimal effort on the part of registrars and registries. It's working within the Registrant Data Access Protocol, the RDEP protocol that registrars have to implement before the end of the year. What the model does is it specifically tackles the question of who's eligible to access the data. What is their legitimate interest? What is their specific purpose? How will they use the data? How may they be accredited in terms of a technical access? Is there a token that you would use to unlock the data? Would there be a centralized WHOIS database that we would access? So these are the things that this model tries to address. There's a detailed purpose statement for the collection and the storage and the processing of this data. The GDPR requires a detailed purpose statement. So the group that has been working on this model has spent a significant amount of time laying out detailed purposes. There's also a proposed operating model and some terms of accreditation around this. So the group that's working on this is hoping to take the work that's been done to date and put it in the unified access model framework that ICANN has provided, and use that as a stepping off point for the community to refine the access model, and hopefully in so doing we'll get to a point where we can get it implemented within a year. And I know that is a long ways out, and so we're going to try to do our best to shorten that. But the fact is, getting consensus on many of these elements of the accreditation access model is going to take some time. And even once that's done, the implementation will also take months, because again, it's a centralized, federated model where we're going to have all registrars and registries be participating in this, so that we can get a consistent output with respect to WHOIS. So with this summary, I'm going to now hand it over to my colleague, Brian King, who will take us through the expedited policy development process, which is what's being used now to evaluate the temporary specification, and also give an update on the working groups. So Brian, come on board and share please your insights on the EPDP.
Absolutely. Thank you, Staten, for kicking it over, and I think everybody can see my screen now. So wanted to give an update on the expedited policy development process that is kicking off now in ICANN land. So as Staten mentioned, the temporary specification that's controlling WHOIS data now is in fact temporary, and the community still needs to come up with a long-term permanent solution for how we do WHOIS in a world where GDPR has everyone scared to publish or allow anyone to access personal data of domain name registrants. So This EPDP is an expedited policy development process because typically in ICANN land, a PDP or a policy development process will take years to carry on. The GNSO is the group within ICANN that does policy. They are responsible for policy making within the ICANN ecosystem, and the GNSO has a lot of groups within it that have interests that need to be balanced and a lot of work that needs to be done to get policy made, and there needs to be consensus among those groups. So you can imagine there's quite a bit of horse trading and negotiation that happens to get this done. So because this needs to be done before May 25th next year when the temporary specification expires, kicking off this EPDP was a big hot topic in Panama. And as an update, we expect the EPDP charter to be finalized next week, and that charter will define the scope of work that the group is doing. So there's some discussion about what should be included. Does access need to be included in the charter and in the EPDP? And we're advocating strongly that yes, WHOIS access for the good guys is critical and does need to be included, or else what's the point of gathering WHOIS data if no one can access it? So that's the update on the EPDP and where it got last week and where we are this week. And as you can tell in this quick fire EPDP, there will be more updates to come, and we'll keep everybody posted on the MarkMonitor blog, and feel free to ask Staten or myself for an update at any time on this. Our contact information is at the end. So let's move to the next slide here. So this is the draft timeline in true ICANN fashion. I think we're already a little bit behind here. We're getting the team together now. The EPDP team should be established with a charter in the next week or so, and then we'll have input from the community, and then the team is really going to get to work for the next couple months and get an initial report out. Now, the thing that makes this expedited is that in a normal PDP, there are a number of stop and take the pulse of the community and public comment periods throughout a PDP. And in the EPDP context, there are only two. There's an initial public comment on the initial report. The comments are reviewed, put together in a final report, more public comment, and then the board is expected then to pass this and make it a permanent policy, consensus policy. So let's shift gears quickly to working group updates. So there's a couple hot topics here that working groups within the ICANN policymaking infrastructure are working on now, and some of them are pretty popular. Subsequent procedures is one a lot of people are interested in. That's new gTLD round 2. There's also a very well attended and long-term working group that is working on, as Staten mentioned earlier, reviewing all the rights protection mechanisms. So let's start with that one. Rights protection mechanisms working group has been busy and has really done a lot of work already. And so the update from the Panama meeting from this working group is that the team is working on the URS. And so the working group team has sent out surveys to URS practitioners and URS bodies that review the URS complaints and decide whether the domain name should be suspended or not. And so the team spent a lot of time in Panama going through the responses received from the URS providers and compiling those responses into general community thought on how the URS is going. And as a bit of background, the URS is a rights protection mechanism available in the new gTLD space, and this is for the quick, no-brainer cases where the intellectual property owner has a word mark. In a trademark, you can't have an image mark or any different kind of trademark. You have to have a word mark. The complaint is limited to, I believe it's 500 words, so it's very short. You have to prove your case very quickly. It's lower cost, but unlike the UDRP, you don't get the domain name if you win the URS. It's simply suspended through the rest of its registration term and then becomes available afterwards. So the group's looking at how many times is the domain registered by the bad guy again after it comes up for availability. and a number of things like that. So this working group is analyzing the URS and will make recommendations for any changes that the group feels need to be made to the URS. Now this group has already done Sunrise and claims, they've already reviewed the TMCH, and the next one that everybody is waiting for out of this working group, the granddaddy of them all, is the UDRP. So that's going to be a very popular time, I think, for eyeballs to get on this working group, and that's the next step. So that should actually be later this year that the group tackles the UDRP. And so keep your eyes peeled. We'll have lots of updates on the UDRP when the working group gets to that point. So the next one that had a big presence at ICANN in Panama was the Subsequent Procedures Working Group. This is the round 2 new gTLD program working group. So what this group is looking at is what changes, if any, need to be made to the new gTLD program. So the policy recommendations that are being reviewed were from August 2007, and the new gTLD round 1 kicked off in 2012. So as you can imagine, there's a lot to discuss that happened over the last 11 years of policy and 6 years of implementation of new gTLD. So the group broke down the work that needs to be done into over 40 distinct topics and organized them into work tracks, is what they're called. And work tracks 1 through 4 have proceeded to the point where they've just filed or published an initial report for public comment. As you remember on the other slide, the public comment period will be open for 60 days, and the public can comment on, provide their thoughts to what the working group has established, and then the working group will take that into account and then publish a final report later. So working group number 5 is on the next slide, and I'll explain why they're a bit behind the other 4 work tracks here in the Subsequent Procedures Working Group. So next steps on new gTLD round 2 for our customers are start to think now, we're still a ways away, but start to think now about whether a .brand TLD is going to be for you in the next round, or if you don't know the types of things you should be thinking about, we can help guide that internal conversation. So work track 5 is still within the Subsequent Procedures working group, but they're tackling geographic names at the top level. So as you can imagine, these can be contentious. There's a lot of regional pride. There's a lot of government opinion on who should be able to get a TLD at the top level and how those should be handled. So this group is behind, and I think 1 through 4 wanted to get their report out. It was a meager 300 pages, just over 300 pages released on Tuesday without work track 5 even involved. So you can imagine why they wanted to get that published and get public comment started. And work track 5 is expected to release their initial report later this year. But there was a lot of discussion in Panama about the difference in how non-capital city names should be treated. They seem to be tackled differently from capital city names in this work track. So you can already see kind of the horse trading and the policy making that goes on behind the scenes here. And the initial feedback is that most people in the working group think that that ICANN should support the continued reservation of the country and territory names like .Italy. So the next steps for work track 5, publication goal is August. We'll see how that goes over the summer months, and then they'd like to publish the final report in 2019. So we'll go to the next slide. So how clients can get involved. So these are some of the groups that MarkMonitor is involved in and represents our clients here. And our clients are welcome to join, and these are some good groups, the business constituency, the IP constituency, both within, actually the BRG, brand registry group as well, are groups within the ICANN governance structure that involvement there has a real effect on policy making. So we're here and we're happy to represent you here, and you're also welcome to get involved and represent your company's interests in these groups as well. Domain name association is near and dear to Staten's heart as well, and we're happy to talk to you more about that. So the next ICANN meeting will be at the end of October in Barcelona. And if anyone has any questions about that meeting, planning on joining, please let us know. We'd be happy to represent your interests. We'd be happy to meet with you at that meeting, and happy to share information leading up to or during or after that meeting as well. So let's kick it back to Brian Costello now for any questions that have come up in the chat.
Thank you, Brian and Staten, for a great presentation. As promised, we will take the next 10 minutes to answer your questions. If you have a question for our presenters, please type them into the Q&A or chat windows, and they are available in the top right-hand corner of your WebEx player. Also, please be reminded, if we do not get to your question today during our Q&A session, we will be sure to follow up with you afterward. So our first question is for Staten. Staten, how has GDPR impacted MarkMonitor?
Thanks, Brian. So for those of you who had the opportunity to hear my GDPR update previously, I went into some detail about what MarkMonitor did to prepare for GDPR and the impact on its brand protection work in a world where you can't see all of the WHOIS data, because as many of you know, our team uses WHOIS data to do anti-counterfeit, anti-piracy, anti-fraud work for our clients. So in anticipation of not having WHOIS to look at, we came up with a three-pronged strategy which we deployed prior to May 25th. One was, the first prong was to hire some additional analysts, because we knew it would take probably a lot more manual effort to go through and look at websites to determine whether there was any usable contact information about a website owner who was doing, counterfeit or other forms of abuse. So we staffed up our brand analyst team. We also deployed a technology that helps us look at metadata behind websites and see if there's any contact information available that we could use to do enforcement work. And the third thing, the third prong of our strategy was to look at other data sources. As many of you know, looking at WHOIS data, you can do reverse WHOIS lookups and triangulate and figure out where an abuser was, operating. And so in order to, have that capability, we looked at some other third-party data sources to help us, do that same sort of triangulation and figuring out of patterns of abuse and where nefarious parties were acting. So we deployed all of those strategies, and I'm pleased to say that, because of the training and those strategies, our team is still able to do a lot of its enforcement. We have not seen too much of an impact on, our enforcement percentages and responses. What it is doing, as we might expect, is taking us a little bit more time to do those enforcements because it takes more effort to find out the contact information of the registrant. But we still are able to do still do effective enforcement. But the other impact has been, of course, on trying to get the full WHOIS data. As I mentioned before, because of the sort of fragmented patchwork nature of the access models that registrars have implemented, when we've requested the WHOIS data from registrars, we get inconsistent response, either no response or full response or partial response, and of course that's taking a lot of time too. So the impacts have certainly been seen in our enforcement work, but we're navigating them. As I told somebody at ICANN, our brand enforcement team is trained to do enforcements by any means necessary. So whatever tools they have at their disposal, they're utilizing.
Okay, great. Next question is for Brian. Brian, when will ICANN open round 2 of the new gTLD program?
Yeah, that's a good question. I'm sure that's, I can't see the Q&A. I'm sure that's one that is on a lot of people's minds, and we've been hearing that question quite a bit. So it's still going to be some time out. It's the Subsequent Procedures Working Group still needs to finish their work. As we saw on the previous slide, Work Track 5 isn't expected to have their report ready, their final report, until at least Q2 of next year. And then once the working group is finished, then any resulting policy work needs to be done. So the working group was going to make recommendations to the community, and then a PDP would probably be launched at that point, a PDP or some other process to guide the kickoff of the next round. So again, that's going to take some time too. So we're still looking at a couple years away, in my opinion, and so it's not going to be an overnight proposition. We have been meeting with the BRG. We've met with MarkMonitor customers and others who are interested in a round 2 sooner rather than later, and we continue to convey those thoughts and ideas to ICANN and the relevant groups and parties there. And so I think those concerns and those yearnings for round 2 are being heard. GDPR is the topic at ICANN these days, and so with only so many hands able to drive policy and to drive things like the next round of new gTLDs, there's still quite a bit to do with GDPR and other big priorities before that happens, realistically.
Okay, understood. Staten, next question. Why are some registrars following the temp spec and others are not?
Also a good question. Thanks, Brian. Well, it has to do with a number of factors. One is, as I mentioned, ccTLD operators are not ICANN contracted parties, so they're not actually required to follow the temp spec. In addition, those who are the gTLD registrars, though required, have also sought legal counsel of their own, and depending upon their jurisdiction, feel that they can or cannot comply with certain elements of the temp spec. And there is a whole process at ICANN for dealing with disputes or conflicts between contracts and local law. And so many of the registrars who feel that under their own country's sovereign law, they do not need or should not or cannot comply with certain elements of the temp spec, they're not doing so.
Okay, and our final question for today, Staten, is an attendee said that they had heard that ICANN sued a registrar. Well, what is the status of that?
Okay, thanks, Brian. That's in reference to the lawsuit that ICANN filed the day of GDPR. They filed a suit against a German registrar, EPAG, based in Germany, who refused to collect the full administrative and technical contact data that was required by the temporary specification. And they refused to do so, arguing that it wasn't necessary for the provisioning of domain name services and therefore not a requirement, therefore was not GDPR compliant. The court in Germany ruled in favor of the registrar, saying that ICANN couldn't require the collection of admin and technical contact information because there was no legitimate purpose for doing so. ICANN has since appealed that decision, and we're waiting for that appeal to be delivered. And ICANN has signaled that it will seek, a decision from the European Court of Justice if necessary on this issue. Why it's so important for ICANN, of course, is to make sure that the temporary specification has legitimacy and legal, has legal backing. So they are really intent on getting a favorable decision. So we'll have to see how this plays out in the next couple of months or so.
Okay, very good. Any final thoughts from Brian or Staten on before we close out today's webinar?
Well, Brian, I know one or two questions in the chat that I think I could answer real quickly. One is, has the change in published data changed the UDRP process? The answer to that is not really. The UDRP providers have stated that if you're unable to identify who the registrant is because of redacted who is, you can file a John Doe or Jane Doe UDRP complaint, and that under the current temporary specification, the UDRP providers will be given the full who is data. So you do not need to have identified your registrant when you file a UDRP. You're still able to do that, and the UDRP provider will be given that access.
Okay, great.
Brian,
anything further?
I see one more there I think we can tackle. The question is, when will the anonymized email or web form system for contacting registrants be implemented? And to that question, that's required as of the moment the temp spec was passed. ICANN compliance will give you the kind of company line answer that that is the new law of the land, and registrars are responsible for having that done immediately. And in reality, it's going to take some time to build those things. I think that ICANN compliance behind the curtain will understand that takes some time, and having worked with ICANN compliance before, I can tell you that they would typically take an approach where they would process a complaint if a registrar had not done that, and they would tell the registrar that they're in breach and they haven't done it, and then give them a reasonable period of time to implement that change, which the registrar is hopefully already working on now. So technically, and the company line from ICANN compliance is that is required as of more than a month ago, and practically speaking, they're going to give the registrar some time to get it in place.
Outstanding. All right. Well, thank you very much, Brian and Staten. Great presentation, great Q&A. Folks, you can see we have contact information for MarkMonitor up on the screen. I believe, Brian, we have another slide with some information. If you need to contact Staten or Brian, you can feel free to contact them directly with their contact phone numbers and email addresses right there. And with that, we thank you for attending our webinar. Please take a few minutes to complete our brief survey, which will automatically appear as you exit the webinar. We'd love to hear your feedback on today's presentation, and if you have any ideas for future presentations that you would like MarkMonitor to present. With that, have a great day, and we will close out our webinar. Goodbye.